Okay, so Luke and Amy. They've got 2 children, Michelle and Joshua, who are both teenagers. Their financial situation is pretty straightforward. They've got a home, they've got a mortgage, they have some super, and importantly, they both have life insurance in place. So Amy's got $1 million on her life, Luke's got 1.5 million on his life. So their goals are pretty straightforward. If one of them dies and wants everything to go to each other, in the event of the death of the second of them, they want the 2 children to benefit equally. In the event that either of the children were to predecease their parents, leaving a child themselves, then they want it to go on to their grandchildren. So, in other words, provide for the various generations of their family. And worst case, if the 4 of them are in a plane and it goes down, they want it to go to their respective brothers and sisters. So, very straightforward. Some of the issues, okay, if Luke was to die first, Amy wants to be able to pay off her mortgage and remain a stay-at-home mum. Just maintain the current situation. So the life insurance is in place to be able to do that, pay out the debt and then also provide an amount of money to invest. If Amy then dies first, Luke wants to be able to continue, but wants to be able to pay for domestic care, childcare, things so that he can retain his job, but replace the type of domestic role that Amy's been undertaking. So if they have a simple will and leave everything to each other, yes, there's significant life insurance. So if Luke dies, Amy invests $1 million, assuming that it's a 5% return, she gets $50,000 a year. On that, if she received that, she pays a bit over $8,000 in tax, so the family receives a little bit under $42,000. However, if they use a sophisticated will, including a testamentary trust so in that case, Amy can use the trust structure to manage the investment. Still the same income, but as you'll see from the slide, there's no tax payable. And the reason for that is that the trust enables Amy to divide the income of $50,000 between herself and the 2 children. Section 102AG of the Income Tax Assessment Act is a very useful, valuable section of the Tax Act when it comes to estate planning, because it says that income received by a child from a testamentary trust or from an estate, the children are taxed as adults. Whereas normally unearned income that a child under 18 receives is taxed at the highest marginal rate. So Luke and Amy's children, both teenagers, if they were working at McDonald's, they're taxed as an adult, but any income they would normally receive that they don't earn themselves, they'd be taxed at the highest marginal rate. But this is an exception. Under a testamentary trust, they would be taxed as adults. So between Amy and the 2 children, no tax would be paid. Similarly, if Amy was to die first, Luke pays off the mortgage, he's got $600,000 to invest. Assuming he's on the 37% tax bracket, he'd be paying a bit over $11,000 in tax on that $50,000 of income. Using the trust structure, the $30,000 of income can be then given to the children. Both of them are under then the tax-free threshold, no tax payable. So instead of the family paying, or instead of him paying over $11,000 on tax, on that $30,000, there would be no tax payable. Okay, if both Amy and Luke passed away, there's going to be about $3.3 million in assets. So if there was a simple will leaving that to the children, yes, they get $1.65 million each at the age of 18 years. Most people, when I talk to them and figures like that, they'll say, oh gosh, that's a lot of money for an 18-year-old. And people are more likely to be conservative nowadays, more likely to say, oh, no, I don't want them to get control until they're 25. So with the sophisticated will, they can in fact do that. Create 2 trusts, one for Joshua, one for Michelle. And Luke and Amy can say in their will, okay, the children don't get control of it until they're 25. So the key is held by their executors. So the executors have the key to the trust. They hold on to it. They can use the money to feed, clothe and educate the children. But once the children turn 25, the key is passed over to them. And then the 2 children can use the trust structure to manage the investments going forward. And that gives them tax advantages because then they can then split income with their own children once they have children further down the track. And it also gives them a structure to keep their inherited assets separate to their own personal assets, which builds in asset protection. So for instance, if they're in a type of profession they're likely to be sued, then it quarantines the investment from their personal assets. And secondly, if they're in a relationship breakdown, once again, it quarantines the assets from their personal assets. So when, I know when we were talking to Cleardocs about the development of the Clear Will, I said, look, it's good to, it's one thing to have a precedent, but you want to make it flexible because I believe that estate planning should be built around the client. The client shouldn't be tried to be fitted into a particular mould that you have. So you've got to try to be flexible in the documentation. So these are a few of the things that I suggested be incorporated. The ability to have multiple and substitute executors. So in Luke and Amy's case, for instance, they may want their respective fathers to be the executors of for the children if the children are under 25. But what would happen if one of the fathers were to die? They want a representative from both sides of the family. So made sure that it was built in so that, you know, if Luke appointed his father and Amy appointed her mother, there are substitutes there. So there was always one member of the family available. So if Luke's father died, you know, his brother could step in. Likewise, if Amy's mother died, her brother could step in. Appointment of guardian for children. Appointing an umpire. Okay, you appoint two people as a trustee. The trust law says they have to act together, they've got to be unanimous. Sometimes that's not easy. Sometimes people can have different views. I mean, I always encourage clients when they're thinking of appointing multiple people, you only appoint people you feel will get along together. Don't appoint people that have got a history of problems between them. But sometimes problems arise. So what we've developed is the concept of an umpire, so that if the people are in dispute, if the two trustees or two executors are in dispute, the matter can be referred to the umpire. The umpire either makes a decision or instigates a process of mediation and arbitration. Provision there also for professional advisors to be nominated in the will, so that if the will makers want their particular lawyer, accountant, financial advisor to be involved in the ongoing running of the trust, they can say so in the will. The ability to give specific gifts. You know, Luke and Amy just wanted everything to each other and to the children, but sometimes will makers may want to give a specific asset to a beneficiary. Obviously, you're given the ability to do that, or a sum of money. But in some instances, it might be a significant asset, maybe a property that they want to give as a specific gift, or a large sum of money. So what I've got them to build in is the ability to give that specific gift itself into a testamentary trust. So if Amy and Luke wanted, say in years to come, if they had an investment property that they wanted to go to a family member, they could actually give it as a specific gift, but incorporate it in a testamentary trust, separate to the testamentary trust for the residuary beneficiaries. A lot of clients nowadays might have structures in place, family trusts, for instance, self-managed super funds. Part of estate planning is obviously looking to see what happens to those structures in the event of death, because the assets, for instance, of a family trust are not the client's assets. So they don't pass under the client's will. But what the client can do is pass control of the family trust in accordance with the terms of the family trust. So if a client has the appointer role, for instance, under a trust, the clear will gives the ability to pass that control onto their chosen person. Also, the ability to create multiple testamentary trusts. Now, some, you know, when we talk to Luke and Amy, they just may want one trust for the two children. There's pros and cons about that. Another option is to have separate trusts, which was the way the case study worked, so that multiple trusts are created. So it's a matter of discussing with the client what they want. The clear will give you the ability to have a pooled trust if that's what the client wants, or to have separate trusts for each beneficiary. The ability to specify appointors for each trust. Now, the normal way that people structure these things would be Luke and Amy would probably say, well, once the children are 25, the children can be the appointer of their own trust. But sometimes that may be not what they want. They may not want the child to be the appointer of the trust. So the will builds in the ability to be able to nominate somebody else as the appointer of the trust. The will has the ability to quarantine death benefits. So superannuation death benefits, the way they're taxed is if the ultimate beneficiary is not a death benefit dependent, tax can be paid by the estate. So the ability under the will is there to be able to quarantine any death benefit received by the estate into a trust, the only beneficiaries of which are death benefit dependents, so as to maintain the tax-free status of a death benefit. The will's got the power, given the power to executors to be able to vary the beneficiary entitlements. And that sometimes happens if for instance, Luke and Amy want the two children to benefit equally, but there's a possibility that one of them may receive money outside the will, either from a life insurance policy, for instance, that's already set up, that's going to go direct to the child, or superannuation that may be going direct to a child. So if that's the case, Amy and Luke may want an adjustment to take place. So if for instance, Michelle is getting an extra $100,000 from an outside source, for that to be adjusted in the division of the other assets, so Joshua gets an equal benefit. So being able to give the executor the power to do that. Giving the executor the power to advance monies for the benefit of contingent beneficiaries, who are usually young beneficiaries. Once the trust is in place, giving the power to the primary beneficiary or the trustee of the trust to vary the terms of the trust. An important clause, because sometimes circumstances change in years to come, and as long as the will maker is happy for the primary beneficiary, the main beneficiary, to have ultimate control of their trust, it's essential to put in there a power to vary the trust if needs be. I looked at a will recently for a client whose father died, and the father has set up a testamentary trust with assets in excess of $200 million. And there's lots of problems with this particular trust. It was poorly drafted, and there is no clause in there allowing it to be varied. So this particular family is facing a lot of problems at the moment, which will probably end up in court because of the drafting issues arising from the will. The other two things I just want to mention briefly are the ability to have what's called a right of residence trust. You know, for instance, you might have a situation where Luke and Amy are in fact a couple meeting later in life, and Amy owns the house and she's happy for Luke to live in the house for the rest of his life, but she wants the house ultimately to go to her children from her earlier marriage. So the Clear Will product enables a right of residence trust to be created so that a property can be put into the trust, giving the husband, for instance, in this case, the ability to live there for the rest of his life, and then ultimately the capital going to the children from the previous relationship. And you can also create a protected trust. And a protected trust is a trust there to protect the beneficiary. So for instance, say if Luke and Amy thought that, say if the son, Joshua, had an intellectual handicap, wasn't able to manage monies, he may need some protection. Or if later in life he had a drug problem, for instance, and they don't want him to have control of the trust, they could give Michelle the testamentary discretionary trust that we spoke about before, but they could opt to give Joshua a protected trust, a trust which somebody else manages for him with the power to use it for his benefit, but he doesn't have the key. So the Clear Will product includes that option in there to be able to create a protected trust. So I've just sort of this morning just gone briefly through sort of some of the things that you need to think about with sophisticated estate planning, and it is pleasing to me that, you know, after, as I said, talking at seminars about this for many years, and being asked, you know, about good precedents, that there is now one available, and I think we're going to have an opportunity in the time we have left to answer any questions that you might have.